All right, hello and welcome back. I guess this is what we're going to be doing for the foreseeable future. So I guess we're just going to continue on with our third unit. And if you recall, and I know it was 2 weeks ago, but we were in the middle of our third unit on criminal law. So what I would want all of you to do at this time is just pause the video, go to morseelaw.weebly.com, and then scroll over units of study, scroll down to criminal law, scroll over to study materials and click. So what you'll see on the third unit page is something that you've already seen, but I just wanted to walk you through what we've already talked about up until this point in the unit. So we've been talking about criminal law. We began by discussing the nature of crimes, with a specific focus on the city of Chicago. And then we talked a little bit about gangs and crime. We watched a video of an episode of Vice that it had shown some immersion journalism where you had that one reporter that was riding around with some gang members from Chicago. You did your Tackling the Gang issue web quest. And then the last thing that we had talked about prior to this point was guns and substance abuse. So we were discussing firearm regulation and the Constitution. If you recall, we were going over some scenarios and whether or not those scenarios would be deemed constitutional under the legal guidance that was provided by the Supreme Court in D.C. versus Heller. So we're going to move on to 3.4. It says victims of crime and intro to criminal law. We're not going to spend any time talking about victims of crime. We're just going to jump right into criminal law. So go ahead and download that file. All right, and let's begin. So, elements of crime. Why do you need to know this? One, because in our legal system, what you are thinking at the time you commit a crime is almost as important as what you actually do. Two, because what you are thinking when you commit a crime is not the same thing as the reason why you commit the crime. And then three, because in order to be guilty of a specific crime, you must complete all of the elements of that crime. This is going to make more sense to you in just a second. So as I mentioned, we're going to skip victims of crime. I want you to scroll down to this slide, Intro to Criminal Law. So almost all crimes require an act accompanied by a guilty state of mind. A guilty state of mind asks, was this crime done intentionally? Was it done willfully? Now, your state of mind is different than a motive. A motive is why a crime was done, as where a guilty state of mind asks whether it was done intentionally. So, for example, if you have Karen ends up burning down, she accidentally leaves her stove on in her apartment, and her apartment complex burns to the ground. Has she committed a crime? The answer to that question is no, she hasn't. Why? Because she would be lacking a guilty state of mind. Yes, she committed the act. She's the one that left the stove on, and as a result of her leaving the stove on, the apartment building had burned to the ground. However, did she do it intentionally? Did she do it willfully? And the answer to both of those questions is no. Might she be sued for it? Perhaps, yeah. But that's not a criminal issue. That would be a civil issue, something that would be resolved not in criminal court, but in civil court. For the purposes of this class, Law 1, all we're concerned with at this time is criminal law. So, how about Robin Hood? So, for those of you who are unaware of the tale of Robin Hood, Robin Hood is this mythical hero that he steals from the rich to give to the poor. Is Robin Hood a criminal? Robin Hood's a criminal. Robin Hood is somebody that not only has a guilty state of mind, this is a man that did take from the rich intentionally and willfully and gave it to the poor. Now, some may argue that Robin Hood's motives were noble, but there is no question that he not only committed the act, but furthermore, he had the guilty state of mind. So Robin Hood, sorry, you're a criminal. So moving on. Some crimes, a few, are what are known as strict liability crimes. Strict liability crimes do not require a guilty state of mind. So you are strictly liable. Liable is a legal term meaning responsible. You are strictly responsible for the act itself. The act itself is criminal regardless of your intent. So, some examples. Statutory rape. Statutory rape is when you have one individual that is above the age of consent has sex with somebody that is under the age of consent. The age of consent differs from state to state. We'll talk about that later on in this unit when we discuss sexual assault. But what is not a permissible excuse in court is, but Your Honor, I thought that she was 17 years old, or she told me that she was 20 years old, or he told me that it doesn't matter what you believed at the time that you had sex with a minor. The act itself is criminal. So statutory rape is a strict liability crime. You have to know the age of the person that you are having sex with. Now, moving on, you have selling alcohol to minors would be another example of a strict liability crime. Selling alcohol to minors, if this man right here in this photo was selling to this boy, and let's say the boy had a fake ID and duped this man into selling him a case of beer, this man would have committed a crime. You have to be absolutely sure that the person that you are selling alcohol to is 21 years old or older. So, elements of crime. Every crime is defined by certain elements, each of which must be proven in order to convict an offender. So, for example, robbery is defined as the unlawful taking and carrying away of goods or money from a person by force or intimidation. There are 3 elements to the crime of robbery, each of which must be proven beyond a reasonable doubt in a court of law in order for the defendant to be convicted of the crime of robbery. If only 2 of the elements are proven beyond a reasonable doubt, but the third is not, a crime still may have been committed, but it wasn't robbery. Every single element must be proven beyond a reasonable doubt. So, if somebody breaks into your house when you are not home and takes your television, can you convict him or her of robbery? What you should be thinking right now is, did that person unlawfully take and carry away goods or money? Was it from a person? And was it by force or intimidation? Now, often when I ask this question in class, I have about half the class that says yes, that is robbery. Half the class says no, that's not robbery. The argument that it is robbery, which is an incorrect argument, but I'll discuss it nonetheless. You have some students say, well, yeah, it was an unlawful taking and carrying away of a television, which would be a good, from a person's house by force. You forced yourself into somebody's house. But that's a misinterpretation of the term person and the term force. So the correct answer is no, this is not robbery. Rather, it's burglary, because not all of the elements are present. Was there an unlawful taking and carrying away of a good? Yes. Was it from a person? That's a no. Whenever the law refers to your person, they're talking about your physical body. And in this case, if they broke into your house when you were not home, they didn't take it from your person. They took it from your house. So we're missing this element. What about that third element, though? By force or intimidation. Well, force would be something that is used upon a person, not some physical structure. So in this case, we're missing force, we're missing a person. The only thing that happened here was an unlawful taking and carrying away of goods, which is still a crime, but it's not robbery. It would be burglary, which is the breaking and entering of a structure with the intent to commit a felony inside. So here's an example of Washington, D.C. law. You have the law of attempted battery and assault. And here in this law, you can see that it says the essential elements of the offense of assault, each of which the government must prove beyond a reasonable doubt, are 1. That the defendant made an attempt or effort with force or violence to injure another person. 2. That the defendant made that at the time he or she made that attempt or effort, he or she had the apparent present ability to injure that person. And 3, that he or she, and I think you get the point, that every single one of those elements must be proven beyond a reasonable doubt in court. Moving on. We're going to talk about classes of crime now. So why do you need to know about classes of crimes? 1, because some crimes are more severe than others. 2, because the more severe the crime a person commits, the longer the sentence the person will receive. And then 3, because the more severe the crime you commit, the less rights you will have in the future. So you have state crimes and federal crimes. Some acts, such as simple assault, DUI, and shoplifting, are prosecuted only in state court, and as were other crimes such as mail fraud, espionage, spying, and international smuggling are only prosecuted in federal court. Some crimes are prosecuted in both state court and federal court. And some examples would be illegal possession of drugs and also bank robbery. These are 2 crimes that you would have a trial in state court, and you'd also have another criminal trial in federal court. Classes of crimes. You have felony, misdemeanor, and infraction, but you probably already knew all of this, so let's just fly through it. Felonies are crimes for which the potential penalty is over 1 year in prison. So this is the serious stuff. Murder, assault, rape, etc. Misdemeanors are crimes for which the potential penalty is less than 1 year in prison. petty theft. So if you, not that you would ever do this, but if you were to snag a classmate's Chromebook on your way out of the classroom, that would go down as a misdemeanor, but it wouldn't escalate to the point of felony. Disorderly conduct and vandalism are also examples of misdemeanors. So a felony is more severe or greater than here. A misdemeanor is more severe than an infraction. An infraction, just think of a traffic ticket or a parking ticket. It's still a crime, but it's an infraction. It doesn't even escalate to the point of being considered a misdemeanor. Next topic, parties to crimes. So why do you need to know about parties to crimes? One, because you can be held criminally responsible for the acts of another person if you help them in any way before, during, or after the criminal act. Two, because the punishment that you will receive for your part in a crime will depend upon what your role was in that crime. So you have four roles or parties to crimes. One is the principal. Every crime is going to have a principal. And this is the person that actually committed the crime. The second role is an accomplice. The accomplice is somebody who helps the principal commit the crime and is somehow present during the commission of that crime. Accessory before the fact is the third party to crimes. The accessory before the fact differs from the accomplice in that the accessory before the fact also helps the principal commit the crime, but is not present during the crime itself. And then the fourth party to crimes is an accessory after the fact. This is a person who, knowing that a crime has been committed, helps the principal or the accomplice avoid capture or escape. So somebody that helps the principal or accomplice hide out. So let me give you a scenario. Follow along with me here. Harold and Marcy decide to burglarize Superior Jewelers. Their friend Carl, an employee at Superior, helps by telling them the location of the store vault. Marcy drives a van to the store and acts as the lookout while Harold goes inside and cracks the safe. After Harold and Marcy make their getaway, Harold meets a friend, Sean, who was not involved in the actual burglary. Harold tells Sean about the burglary, and Sean helps Harold get a train out of town. David, a former classmate of Harold and Marcy, witnesses the crime but does not tell the police, even though he recognizes both Harold and Marcy. How will each person be charged? Let's go one by one. So let's start out first with their friend Carl. Carl, he's an employee at Superior Jewelers. He helps them by telling them the location of the store vaults. We have four parties or potential roles that Carl could be labeled as. Is Carl the principal, the accomplice, the accessory before the fact, or the accessory after the fact? Carl would be an accessory before the fact. This is a man that had helped Harold and Marcy commit this crime, but Carl wasn't there when Harold and Marcy were actually committing the crime. Therefore, he is not an accomplice. He is an accessory before the fact, before the crime ever occurred. Marcy drives a van to the store and acts as the lookout while Harold goes inside and cracks the safe. Is Marcy the principal, the accomplice, the accessory before the fact or the accessory after the fact. Marcy would be considered the accomplice. Carl was not at the jewelers at Superior when the crime was committed, which makes him an accessory before the fact. Marcy was there. Marcy drove the van to the store. She was the lookout. She was present when the crime was occurring. She would be the accomplice. She would not be the principal because she didn't actually go inside and burglarize the jewelry store. Rather, she stayed outside while Harold went inside and cracked the safe. Therefore, Harold's role would be the principal. Harold tells Sean about the burglary, and Sean helps Harold get a train out of town. What's Sean's role in this case? Crime already happened, so he wouldn't be an accessory before the fact. He wasn't there while the crime was happening, so he can't be an accomplice. And he didn't actually burglarize the jewelry store, so he can't be the principal. But Sean did help Harold avoid capture, therefore making Sean an accessory after the fact. He was an accessory after the crime had already occurred. And then the last one. David, a former classmate of Harold and Marcy, witnesses the crime but does not tell the police even though he recognizes both Harold and Marcy. What is David? Principal, accomplice, accessory before the fact, accessory after the fact. The right answer is David's nothing. David's actually free of criminal liability in this case because you are under no legal obligation to report a crime if you witness it. So in this case, he did witness the crime occurring, but he didn't actually help Harold and Marcy in any way. He didn't intentionally go out of his way to help them avoid capture. Or, you can make that argument, and if you made the argument, because some of you are probably thinking he kind of did. That had he just called the police and said, "Hey, yeah, no, that was totally Harold and Marcy. I went to high school with them," then they would have been captured. But the law does not require you to call the police if you witness a crime. So in this case, David actually would be free from criminal responsibility. Crimes of omission is the next topic that we're moving on to. Why do you need to know about crimes of omission? One, because in some rare circumstances, you will be held criminally responsible for not doing something that you should have done. And then two, because in many jobs, you will have the legal responsibility to do things and can be criminally punished if you fail to do them. So, some examples of a crime of omission. A crime of omission. Well, let me first break this term down for you. So, if you wrote an essay and I ended up striking through a word and I write the word omit, O-M-I-T, above it, what am I telling you to do? I'd be telling you to remove that word. Omit means to take out. So with a crime of omission, something is missing, something's not there, something's been removed, something that is required of you is not being done. So some examples. Not paying your taxes. So tomorrow is tax day. Oh, I'm sorry. Tomorrow is April, which would be tax month. Usually taxes are due on April 15th. You are going to have to pay them. I have to pay them. Everybody's got to pay their dues. And so the law requires you to pay your taxes. If you don't pay your taxes, you don't get to say to the federal government, oh, but I didn't know. No, that would be a crime of omission. That the law requires you to do something and you didn't do it. So you're being punished not for something that you did, but rather something that you failed to do. Not stopping after getting into a car accident would be another example of a crime of omission. Law requires you to do it. You didn't do it. You committed a crime. This just happened to me last year. I was driving home from Elgin, and I ended up getting sideswiped by a vehicle that I wasn't able to get the license plate. Car just kept driving on down Roosevelt. I went to the cops. The cops said that there were no video cameras in the area, so they weren't able to an arrest. This one applies to me. As a teacher, all of your teachers have to sign what's known as a mandated reporter form when becoming a teacher. So when I accept a teaching position, I have to sign this form, and it says that if I am aware of any signs of child abuse in one of my students, I am legally obligated to report that to DCFS, DCFS being the Department of Child and Family Services. If I do not make that phone call, and I have had to make that phone call like 2-3 times during my career, if I don't make that phone call, then I can be charged with a crime because the law is requiring me to do something and I'm failing to do it. And then the last example that I have here is mechanics letting people drive off with no brakes. Law requires mechanics to ensure that a vehicle is safe for operation when it is driven off the lot. If a mechanic knows that a vehicle is lacking the brakes and lets the customer drive off anyway, the mechanic would be charged with a crime. And I believe this is the last topic that we're going to be talking about today, preliminary crimes. Preliminary crimes. Preliminary means before the fact. So think of when we watched 12 Angry Men, you had that initial scene where the jurors had walked into the jury deliberation room, sat down, and then they wanted to take an initial vote, a preliminary vote. The preliminary vote was taken because they wanted to know where everybody stood before they even talked about it. So preliminary means before the fact. So preliminary crimes, why do you need to know about them? Because some acts that occur prior to a crime happening are also punished. 2, because preliminary crimes are complete crimes in and of themselves and require very little to be complete. So there's 3 preliminary crimes. 1 is solicitation. Solicitation is when a person asks, commands, urges, or advises another person to commit a crime. So you can think of a mob boss. If you have a mob boss that ends up issuing a hit on a rival mobster, that mob boss is not likely to kill that rival mobster by himself. Rather, he's going to solicit murder. He is asking somebody else, somebody that works for him, to commit the crime on his behalf. You often hear this term when hearing about solicitation of prostitution. So prostitution is a crime, and a solicitation of prostitution would also be a crime, because that would be somebody asking another person or urging another person to commit a sexual act that is illegal, a crime. So if a police officer is watching a man handing money to a prostitute, that police officer does not need to wait for the actual act to be committed before making the arrest. That this simple handing over of money to the prostitute is enough evidence to suggest that that man is soliciting a crime. He is asking another person to commit a crime. Next, attempt. Attempt is when somebody performs all of the elements of a crime, and we talked about elements earlier on in this lecture, but fails to achieve the desired results. So think of the crime of murder. If one person ends up raising a gun, shooting a gun, and hitting a victim, that victim goes to the hospital and lives, well, they can't be charged with murder because the perpetrator didn't actually murder anybody. So does that mean that we just don't charge that perpetrator with a crime at all? No, of course we do. It would be the crime of attempt. That perpetrator, the shooter, would have performed all of the elements of that crime, but just failed to achieve the desired result, which was the killing of the victim. So in order for an action to be considered an attempt, there must be some sort of substantial step taken towards committing the crime. The last preliminary crime, a crime that is committed before the actual crime is committed, is conspiracy. Conspiracy is an agreement between two or more persons to commit a crime. So, and what I should mention is that an overt act is required for conviction. This overt act, let's talk about what that looks like. If there are a man and a woman agree to go rob a bank, and the woman goes to a local convenience store to purchase a ski mask, that would be an overt act. This is something that so clearly is indicative of the fact that they're about to do this crime. The law allows the police to make the arrest even though that crime hasn't actually occurred yet. So you often hear in the news now a conspiracy to commit terrorism. So if you have two conspirators, let's say two men that agree that they're going to commit a terrorist act, that would be a case in which the police do not need to wait for the act of terrorism to have occurred before making the arrest. That they can act on this conspiracy charge so long as there was some sort of overt act to suggest that one of the two men or both of the two men were going to commit an act of terrorism. So let's go over a couple scenarios here. Would any of the individuals involved in this scenario be guilty of the crime of attempt? Martin, a bank teller, figures out a foolproof method of stealing money from a bank. It takes him some time to get up the nerve to steal any of the money. Finally, he makes up his mind and tells his girlfriend, Maria, that tomorrow he will steal the money. Maria goes to the police, and Martin is arrested an hour later. So is anybody in this scenario guilty of the crime, the preliminary crime of attempt? What you have to think now is if attempt is defined as when somebody performs all of the elements of a crime but fails to achieve the desired results, did Martin perform all of the elements of the crime of embezzlement but just failed to achieve the desired result? Did Martin take some sort of substantial step towards committing the crime? In this case, no. Martin is not guilty of attempted embezzlement. Embezzlement, and we'll learn about that term later on. But what embezzlement is, it's when somebody entrusts you with money and you use it in a way that is different from how it was entrusted to you. We'll get to it. So in this case, Martin tells his girlfriend that he is going to steal this money, but he doesn't. Does that amount to a substantial step towards committing the crime? Under the law, probably not. That there needs to be something more there. What about this scenario? Gil, an accomplished thief, is caught while trying to pick Lewis's pocket. So kind of stick his hand in Lewis's pocket as he's walking and then take maybe his wallet. He pleads not guilty and says he cannot possibly be convicted because Lewis did not have a penny on him. Would Gil be guilty of the crime of attempt? So let's think. Did Gil perform all of the elements of a crime but fail to achieve the desired result? Was there some sort of substantial step that was taken? Well, in this case, the crime would be theft or larceny. Yes, Gil would be guilty of attempted larceny. He did everything that he could to steal money out of Lewis's pocket. It doesn't matter that Lewis didn't have a penny on him. Gil can't say, if upon being arrested and then charged with this crime, but officer, but your honor, I can't be charged with theft because I wasn't able to steal anything. No, there would be attempted larceny. What about this one? Rita and Anwar decide to rob a liquor store. They meet at a pub and talk over their plans. Rita leaves to buy a revolver, and Anwar leaves to steal a car for use in their getaway. Rita is arrested as she walks out of the gun shop with her new revolver. Anwar is arrested while trying to hotwire a car. So would any of the individuals be guilty of the crime of attempt? Rita bought a gun. Anwar was trying to hotwire a car. In this case, no. No one is guilty of attempted robbery. It wouldn't be attempt because all of the elements of robbery were not completed. So it doesn't make it an attempt. Rather, this would be conspiracy, that you had an agreement between two people to commit a crime, and there was some sort of overt act towards completing that crime, but they did not perform all of the elements of the crime. So it's not an attempt. In this case, they had conspired. This would be a conspiracy. And the last one. Would any of the individuals involved be guilty of the crime of attempt? Amy decides to burn down her store to collect the insurance money. She spreads gasoline around the building. She is arrested while leaving the store to get a book of matches. Amy is guilty of attempted arson. She was doing everything in her power to actually commit that arson. Arson is the burning down of a structure. She's doing everything in her power, but she just didn't have the matches on her. That she had completed all of the elements except for lighting the match. So she didn't get her desired result, but she took some sort of substantial step towards committing the crime. This would be attempted arson. All right, that's all I have for you today. I'll see you next time.